Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Richard Casey III, partner at Robinson and Casey P.L.L.C. Richard focuses on helping families navigate legal options when addiction or serious mental illness creates an urgent safety concern. His work includes the Marchment Act cases, mental health guardianships, and advocacy around treatment access and oversight. I'm Lisa Mosbey, and today we're talking about what can happen if someone leaves treatment early during a Marchment Act case and how that impacts what happens next. Thank you so much for joining me today, Richard.
It's nice to join you, Lisa. Thank you for having me again.
Richard, once someone enters treatment through a Marchment Act case, families often assume the process will continue as planned. What happens if someone leaves treatment before completing the phase?
Yeah, so obviously one of our goals is to keep people engaged with treatment, and the Marchment Act provides a decent amount of leverage, not just for families, but for treatment centers to help keep them engaged over the long haul. The point is to have bumpers on the bowling alley, like I like to call them. And so the individual can be kind of moving down the lane of treatment. There's no designated area. They're not always going in a straight line, but when they get to the edge, there's a bumper to keep them traveling down the lane, and that's what the Marchment Act provides. What could happen is obviously the individual could refuse. They could choose to walk out the door. It's the benefit of the Marchment Act can also have its own downsides. One of the benefits of the Marchment Act is that the facilities to which an individual can access, so the facilities to which a family can actually petition and get the court to enter an order for their loved one to get treatment at, are the same facilities with the same quality in the state of Florida that anybody who's going voluntarily can access. It's not your stereotypical forensic hospital environment that we're talking about. These aren't locked units, so the doors don't lock just because we get the court order. It is the court order that provides that insulation and protection and the consequences for someone's noncompliance. But the benefit is that there's a lot more dignity, and there's a lot higher clinical acumen, and there's a lot more specialization that a family can access by picking the particular provider that works best for the clinical care delivered, the particular milieu or environment that would be most appropriate for their loved one, right? The right type of financial obligation for the family, access to potential insurance, so they can gauge their needs and determine the facility they would most likely to use anyways, and access that facility, but then also add the layered protection of the Marchment Act around them, which gives a real and direct consequence if the individual does not comply. That doesn't mean the doors lock, and it doesn't mean that the SWAT team shows up if they threaten to leave. But what it does mean is that the individual who leaves treatment is immediately subject to court oversight, and we can file a motion to hold them in contempt, the consequences of which could be incarceration for up to 6 months. So the individual's told that. That's the risk of refusing to follow the court's orders. And often, the mere knowledge of those consequences is enough to put those guardrails on the mind of the patient, allow them to stay in that much nicer environment, right? Going through these nice, quality private treatment environments and get the care and help that they need versus risking the chance that the court will incarcerate them. Now, there's other consequences. They could be fines. They could have other types of persuasive or punishing components, depending upon the type of contempt that they're being charged with. There are civil and criminal contempt. Often, we're looking for civil contempt proceedings and not criminal contempt, which would mean a significantly reduced chance at 6 months incarceration, but it could still be up to 6 months. And the benefit is that when we talk about civil contempt, the court lawyers talk about it as, well, the person being held in contempt holds the keys to the jailhouse door. They get a provision called a purge provision. So they're held in contempt. The consequences prescribed by the court. That could be persuasive or punishment. In a civil proceeding, it's supposed to be persuasive. And that means that they must have a purge provision, a provision that allows them to get themselves out of contempt. And that provision is almost always going back to treatment to finish the rest of the order, right? So it becomes, you can walk out now, and then we'll bring you to court, then we'll pick you up with the sheriff, we'll bring you to jail, we'll drag you back into the courtroom, and then we'll have a nice conversation about if you'd like to go back to jail, you can, or if you have the keys to the jailhouse door, you can follow the court's orders and go back to treatment. We just might restart the 90 days all over again, though.
So, Richard, when somebody exercises that purge protection, I understand that to be one legal method for them to get back into treatment. But are there other legal or practical options that exist for getting someone back into treatment after they leave early?
Yeah, so obviously we're not our goal is not to have to file motions to show cause or the technical term for how to hold someone in contempt, right? Our goal is to immediately have the facility intervene, use the leverage of the existing order, call local law enforcement to have local law enforcement come and have a dialogue with them. If the local law enforcement is willing to transport them back to treatment, they can, right? That's kind of the call of local law enforcement. And sometimes it can be necessary for the patient to be redirected. It matters the language in the potential order, whether local law enforcement is actually authorized to take them against their will at that moment. But they'll usually be pretty clear, hey, if you don't go back, we could have to go down this path, right? If they still don't go back, family can get in touch with the individual. We can host interventions. They're allowed to walk back into treatment so long as they make arrangements with the facilities to do that, right? So there's nothing prohibiting the individual from going back into treatment to try to get that care or help once they walk out. But there are consequences for refusing to stay in compliance with the court's order, right? By not going back into treatment. And it could escalate as far as being held in contempt, then being incarcerated. And then the only way out of incarceration would be that purge provision, which is whatever the court sets it as. We've had them be, you know, very, very specific, where the court said, we're going to skip jail. We're going to send you back to treatment. But my purge provision is finish the 90 days or you go to jail for 6 months, and we'll go right to criminal contempt. And so, it's kind of like there are going to be courts that have their nuances, and every county is going to be different and every judge is going to be different. So we know the kind of nuanced differences that can occur from county and jurisdiction to jurisdiction, and how hard it is or how easy it is to get into these postures. But ultimately, our goal is treatment. So we're not looking to or strategizing consequences on the beginning, other than the guardrails and consequences of their substance use are, or I should say, the consequences of their substance use and not getting help for treatment are the guardrails of the Marchment Act in treatment.
And then how do treatment providers typically respond when someone tries to leave or actually leaves during the process?
So I've found historically that most treatment providers do a pretty good job with trying to intervene with the patient if they're made aware of the departure. And they try to use the leverage of the Marchment Act and communicate and help them restabilize and help them understand that they don't want to suffer those consequences. And it's best for them to stay engaged with the treatment process. The unfortunate reality is that sometimes substances have hijacked the mind, right? And their cravings to go back to use drugs or alcohol have hijacked that patient's mind. And they don't talk to anyone about their leaving, they scale the wall. And so often treatment facilities will use their tools to the best of their ability. If they have signed releases of information to communicate with the family, they will. If they have a patient who technically goes missing, they will likely contact law enforcement to file a missing persons report with the police. If they have the court order paperwork where they're named, they'll likely file a letter with the court per the order's requirements, indicating or notifying the court. If they have us as a named, they have a signed release of information to communicate with us as a law firm. They'll let us know as well. So they're going to take as many of those postures as they're allowed to, but they obviously have to follow all the types of compliance and laws that regulate the licensure of a substance use treatment program. So at a bare minimum, they're usually going to notify the court because they have a court order that indicates their need to let that court know if an individual leaves treatment without approval. And then it can obviously include the missing persons, notifying us, notifying the family.
And then when that happens, what should families expect in terms of how the situation may unfold from that point, or if the Marchment Act can actually move forward?
Yeah, so once the order's in place, obviously we kind of talk a little bit about this in talking about contempt, right? So once the order's in place, the court has required the patient to follow the rules of the facility. And if they're leaving treatment, technically the court is not aware if that was because the treatment facility said they were done with treatment or because they left when they weren't approved, right? And so if the treatment facility is saying they were not approved to leave, then the court has more ability, obviously, to hold them in contempt. So what would normally happen? What would the family suspect to happen? Well, the court should be notified. We should be notified. If the facility can't notify us, but the facility can notify the family should let us know right away. We're representing them. We want to be able to help, and we can't if we don't know. Um, so someone should likely try to contact law enforcement, whether that person's a missing person or whatever. We might be able to intervene with them, right? They obviously are someone that suffers from a specific condition that's already been determined by the court to um, implicate their ability to either determine what type of treatment they need, which is what they're choosing to do, even though they don't have that ability, or it implicates their ability to care for themselves without potentially running into self-harm if they're not in treatment. So we've kind of looking at these two scenarios where an individual has chosen to not receive treatment, and either they were determined that if they're not getting treatment, they may neglect or refuse to care for themselves, or they can't appreciate exactly what type of treatment that they need, or both of those things. And so we want to tell law enforcement because we want to have them at least go and check on the patient, as well as we want to notify the court. And the facility can do that, but the family needs to do that too. We can come together at a hearing to actually prove that this individual left treatment without approval and that the court should implicate a motion to show cause proceeding, holding them in contempt.
Richard, I'm curious if you have a scenario in your head, maybe a story of somebody who has gone through this process and left treatment. Share with our audience, how did it resolve?
Yeah, obviously one of the most important things is for families to follow our advice. And I don't mean to say that because we know it all, but we obviously want to put the most amount of resources in the family's hands to get their loved one back into treatment. So we've had many a scenario where families are following our advice. We're following the motions when they are supposed to follow the motions. They're holding them in contempt. They're notifying them of the proceedings. We've actually had people who have figured out a way to get out of the state of Florida. And even though law enforcement in another state won't physically extradite them back to Florida, what we've done is we've indicated that this warrant will continue to remain in effect in the state of Florida for their arrest after getting a contempt proceeding. And then if they'd like to resolve an outstanding warrant for them, they must return and have this addressed. And we've gotten people back into the state. We've done everything short of that as well. We've had to have warrants executed in the state. We've issued them. We've had people brought into incarceration, and then we've had them purge. And we've also kind of let them know that this is the proceeding and this is how we will have to go forward. But the individual learns that that's what could happen. Self plays out the tape and determines that it's better for them to go back into treatment before we have to go down that path. So what we have had a variety of examples across. So what can occur? Most often, an individual is not initially reaching out to their loved one. They're really leaving treatment because their cravings for substances have gotten so extreme that they've just kind of been pulled back to go use. And they're fighting internally with that craving, and they run away and they go and get substances. Now, absent the Marchment Act, that probably would have happened much sooner, and there's zero leverage to get them back into treatment, right? So now we've gotten them a lot further down the path than they would have otherwise gotten, right? And we have leverage to get them back into treatment. So what will we do? We will use the tool both practically as leverage to communicate to them, listen, this can only get more difficult for you. Please don't go down that route. Like, we gain nothing by that. And so let's get you back into treatment now. And often a patient will be redirectable. They might have to go to a different treatment program because the first treatment program is not willing to take them back because of their noncompliance, or they might be able to go right back to where they started. But more often than not, they'll detox and they'll go back in through the top-down mechanism. We might still go to court and ask to renew the 90 days to create a consequence. You can't just go out and use and then pick up where you left off. There's going to be a consequence. We just might ask that the clock get restarted. We want 90 days of treatment, not 20 days and then 10 days off and 20 days and 10 days off and 20 days and 10 days off, right? So we might, 20 days in, they run away. We restart the 90 and say, hey, next time when you get to day 20 and you get that craving, you don't want to restart the 90-day clock. Why don't we stay engaged with treatment instead? And so those are kind of the tools that we prefer to go towards.
Richard, can you leave our audience with a final thought? The families who might be struggling with someone who has left treatment early during the Marchment Act, what guidance can you leave these families with today in support of their loved one and to continue this process?
Yeah, I mean, obviously the goal is not to be in the position where people are leaving early for treatment regardless. So, like I've said, we've had individuals who have left early, and we get the best results when the families are ready to take immediate action and put immediate consequence down for those patients. I'll share a not as favorable of a story to help illustrate why it's so important to do the right thing. And so we've had one particular case I can recall the most, where a young woman was under the Marchment Act for a period of time. The court had granted multiple extensions. She was in a residential environment, and the family continued to be of the mindset that they were a little afraid that their daughter wouldn't love them, that she would withhold her love over if they continued to enforce the Marchment Act. And you could see that playing out in how they kind of continued to not be as serious about the boundaries as she would break little rule after little rule. And so they wouldn't continue to enforce the Marchment Act. She'd leave for a day and come back. I don't really want to do the restart of the 90-day program. Oh, wait, I'm not going to make you, but obviously eventually got to the point where she absconded completely. And the family told us that they didn't know where she was located, and so they wanted to hold off on spending the money on the motion to show cause. They didn't want to pay us the fee that was required for us to file additional paperwork multiple months down the road to hold her in contempt. And I'm not going to begrudge someone. There are financial realities in the world, and you're telling me you don't know where she's located, and so she's not picking up her phone. Like, you're acting as though there's going to be no way that we could give her the court date. Little did I know, they actually did know where she was located. They were paying for her hotel room that they were put her up in, and they were making additional plans to send her to Mexico to get ayahuasca treatment or some other version of, right, kind of, they were hoping that there was some other solution out there besides being tough parents. This was something she loved because she was now staying in a hotel room with her boyfriend, and they were giving her spending money, and she was using that spending money to buy drugs. And unfortunately, that young woman didn't survive. So we were notified during the pending of our order that she died. And so that we had to go back to court and notify the court that the order obviously needed to be resolved because there was no way to hold someone accountable. And we had to file the proceedings to dismiss the case because she passed away. And so I think some families are just always struggling with this mix of seeing their child like the innocent kid they raised, and the difficulty that the substances have created, and the screaming and the yelling and the threats of removal of love. And they are torn. And I understand that. I lost my father to alcoholism. I have a stepson who's 8 years old. I see him grow. Like, I'm starting, I get the perspective. I'm in recovery myself. I know what my family went through and what I put them through. So I've been through it all. I've got aunts and uncles and cousins, and we have a lot of recovery going on in our family and a lot of people who aren't in recovery in our family. And so I've had this, exposure. And so I know what they're feeling, but it's hard as their lawyer to get them through this emotional hurdle. So the most important thing is really these types of strict and difficult boundaries aren't really that strict. You're really just asking them to go to treatment. And that if they don't go to treatment, you're not going to support them financially. And that in fact, you might actually let the court or even ask the court to implement a consequence so that there is a direct consequence for a direct behavior. They're an adult. They're under an order. It's just like the requirement to pay child support. If you don't pay the child support, the court can exercise its authority of contempt over the individual refusing to pay child support. This is an adult. They're using substances. They are required to go to treatment. If they don't go to treatment, the court can exercise its authority to hold an individual in contempt for refusing to follow the court's order. Like the consequence is not imprisonment for 20 years. It's not a criminal behavior, but there is a requirement that in society that if you have a responsibility as an adult, you suffer a consequence for refusing to do it. And families need to be okay with letting that happen to their loved one. In fact, requiring that be the consequence they face, because it's a much smaller consequence than the consequence of continuing to use drugs and alcohol, which will devastate their lives, devastate their family, and could lead to much worse consequences than a day or two in jail.
And we'll leave it there. Thank you so much for your vulnerability, your guidance, and your stories, because I think that's what helps families realize that this is serious and that sometimes we do need to use tough love. So thank you for your conversation today.
No problem, Lisa. Thank you so much for having me.
Folks, that's it for today's episode of A Way Forward, The Right to Recover. If you'd like to learn more about Richard Casey and the work of Robinson and Casey P.L.L.C., including resources related to the Marchment Act in Florida, please visit robinsoncasey.com. And thank you for listening. Don't forget to leave a review, and share this episode if you know someone who is struggling and needs to get help now. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.